Okay, we're going back into meeting today for a petition hearing, and we'll turn it over to the Administrative Law Judge.
Thank you. Sorry. Good afternoon, everyone. Ready? All right. I will open the record in the matter of the petition for reinstatement filed by Todd Gaffney, Ph.D. This bears Office of Administrative Hearings case number 2019-080943, agency case number 6002018-001056. Today's date is October 3rd, 2019. My name is Deborah Nye Perkins. I am an administrative law judge with the State of California's Office of Administrative Hearings, and I am here today sitting with a quorum of the Board of Psychology, which is convened today to consider this petition. May I take appearance of counsel for the record, please, beginning with the Deputy Attorney General.
Good afternoon, everyone. Rose Luzon, Deputy Attorney General, appearing on behalf of the Attorney General of California.
Good afternoon, Your Honor, members of the board. Lindsay Johnson, on behalf of Petitioner Dr. Todd Gaffney, who is present and seated to my left.
Good morning, counsel. Before we get started, I note I've been handed a binder of documents that I think everyone has, and I'm going to mark those documents for identification purposes first before we move into the actual meat of the hearing. So, and hopefully they will follow along with the tab, so it should be fairly simple. Under tab 1, I have a redacted copy of a notice of hearing in this matter, and as well as some guidelines. These bear off the Bates number on the lower right-hand corner, AGO 0001 through 3. I'm going to mark that as Exhibit 1. Under the next tab 2 is a certification of licensure, and I'm going to mark that as Exhibit 2. It's a one-page document. Under the next tab 3 appears to be a decision dated April 9th, 1993. It is Bates numbered on the bottom right-hand corner, AGO 0005 through 0019. I'm going to mark that as Exhibit 3. Under the next tab 4 is a redacted copy of the petition for reinstatement. It is Bates numbered AGO 0020 through 37. I'm going to mark that as Exhibit 4. Under the next tab 5 is a redacted copy of the petition for reinstatement of a surrendered license. And it is appears to be a investigative report. It is Bates numbered AGO 0038 through 51. I'm going to mark that as Exhibit 5. Under the next tab 6 is a document that is Bates numbered AGO 0052 through 68, and it appears to be a transcription of Ms. Luzon, maybe you could tell me what that document is?
Yes, Your Honor. It's a transcription of an interview that was conducted with Dr. Gaffney and his attorney in connection with a petition.
All right, that's all that's all marked as Exhibit 6. Under the next tab 7 is a letter dated June 12th, 2018. Single-page document that's Bates numbered AGO 0069. I'm going to mark that as Exhibit 7. Under the next tab 8 is a redacted letter from Ann Johansson. It's Bates numbered AGO 0070. I'm going to mark that as Exhibit 8. Under the next tab 9 is a redacted one-page letter dated 6/12/2018. It's Bates numbered AGO 0071. I'm going to mark that as Exhibit 9. Under the next tab 10 is a letter dated June 11th, 2018, a single-page document, Bates numbered AGO 0072. I'll mark that as Exhibit 10. Under the next tab 11 is a letter dated 6/19/18. It is redacted. And then there is another letter, page 2 of that letter is also redacted. The letter is Bates numbered AGO 0073 through 74. I'm going to mark that as Exhibit 11. Under the next tab 12 is a redacted letter dated June 12, 2018, Bates numbered AGO 0075. I'll mark that as Exhibit 12. Under the next tab 13 is a redacted letter dated 6/20/18. It is 3 pages in length, Bates numbered AGO 76 through 78. I'll mark that as Exhibit 13. Under the next tab is a redacted single-page letter dated June 17th, 2018, Bates numbered AGO 0079. I'll mark that as Exhibit 14. Under the next tab 15 is a redacted letter dated June 17th, 2018, Bates numbered AGO 80. I'll mark that as Exhibit 15. Under the next tab 16 is a redacted letter dated July 22nd, 2018, Bates numbered AGO 81. That's Exhibit 16. Under the next tab 17 is a letter dated 6/29/17. It's a 2-page letter, Bates numbered AGO 82 through 83. I'm going to mark that as Exhibit 17. Under the next tab 18 is a single-page letter, Bates numbered AGO 0084. I'll mark that as Exhibit 18. Under the next tab 19 is a letter dated June 22nd, 2018, Bates numbered AGO 0085. That's Exhibit 19. Under the next tab 20 is a single-page letter, Bates numbered AGO 0086. It's a letter dated June 22nd, 2018. I'll mark that as Exhibit 20. Under the next tab is a decision sheet document with some attachments. These are Bates numbered AGO 0087 through 117. And I'm going to mark all of that as Exhibit 21. Under the next tab 22 is a redacted copy for a request for live scan service. It's a single-page document, Bates numbered AGO 118. I'll mark that as Exhibit 22. Under the next tab 23 are certificates, is a certificate of training as well as a letter from Robert Johansson, and also some certifications. These are all Bates numbered AGO 119 through 124. I'm going to mark that as Exhibit 23. Under the next tab, 24, are documents Bates numbered AGO 125 through 131. I'm going to mark that document as Exhibit 24. Under the next tab, 25, these documents are Bates numbered AGO 132 through 137, and it includes a curriculum vitae as well as a letter. I'm going to mark all of that as Exhibit 25. And then the last tab, 26, is a copy of the disciplinary guidelines for the Board of Psychology. I'm going to mark that as Exhibit 26. It's Bates numbered AGO 138 through 172. Are there any further documents to mark from either party?
I can allow Petitioner's Counsel to introduce the exhibit that I think she'd like to have more.
Oh, you have an additional exhibit to mark?
We do, Your Honor, just one.
Okay. Do you have copies?
I do.
Oh, great.
Looks like they're going around right now.
Thank you. This looks like it might be duplicative, or no? It's not?
No. These are new continuing education that was completed this weekend.
Oh, well, then it's not. Okay, I'm going to mark this as Exhibit 27.
Thank you, Your Honor.
Any further documents to mark, Mrs. Johnson?
No, Your Honor.
Okay. All right. Ms. Lozano, a preliminary statement?
Thank you, Your Honor. Well, we're here this afternoon on a petition for reinstatement brought by Dr. Todd Gaffney. By way of background, on May 9th, 1993, petitioner's license was revoked following the board's adoption of a stipulation for revocation of license that was signed in December of 1992. The underlying facts that gave rise to petitioner's loss of license were as follows. Between March 1983 and July 1986, the petitioner was a registered psychological assistant under the supervision of a licensed psychologist. Prior to that, during various timeframes since 1977, the petitioner was a registered psychological assistant. He received his psychologist's license on July 18, 1986. In February or March of 1985, he commenced therapy with a patient known by the initials JW at his private practice office. Concurrently, petitioner had been a professor of psychology at Cerritos College, and JW, at one point, had been a student at Cerritos College. Petitioner and JW engaged in a sexual relationship between March 1985 through at least November 1986. During this time frame, JW received individual therapy from respondent and attended his group therapy sessions. To hide the relationship, petitioner contrived a payment arrangement whereby, in lieu of monetary payment for therapy, patient JW provided services on his behalf as a Cerritos course facilitator, as a SCI Beta officer, and as a project helper. An accusation was filed before the Board of Psychology against petitioner on March 30th, 1990. The accusation charged three things. One, that petitioner engaged in sexual relations or misconduct with a patient in violation of Business and Professions Code 2960 Subdivision N. That petitioner committed gross negligence by engaging in dual relationships with a patient and by engaging in bartering for services with that patient in violation of Business and Professions Code Section 2960 Subdivision J. Lastly, the accusation charged that petitioner misrepresented the status of his license in violation of Business and Professions Code 2960 Subdivision C. The petitioner stipulated to have his license revoked in December of 1992, and that revocation went into effect in May of 1993. As a housekeeping matter, I want to note that at times you're going to see references to, in the petition and in some of the exhibits, that petitioner surrendered his license. Other times you'll see references that petitioner's license was revoked. So I just want to make the record clear that this is a difference in verbiage only, and it's a result of what stipulated settlements of this kind were called back in 1993 versus what they're called now. So for our purpose, the proper title of the instant petition is Petition for Reinstatement of a Revoked License. And the use of the word surrendered, let's agree that it's interchangeable with the word revoked. At this point in time, as you know, it is the petitioner's burden to demonstrate rehabilitation. And it's his burden to demonstrate that, based upon clear and convincing evidence, that his license deserves to be reinstated. So at this time, what I'll do is I'll rest. I'll wait for the petitioner to testify subject to my cross-examination.
Thank you, Your Honor. Very briefly, because I imagine the board is most interested in hearing from petitioner. For over 44 years, petitioner has worked in the profession, albeit the majority of it in a non-licensed capacity. And now, after that time period, he comes before this board asking for a second chance to hold his license. It's a chance that he admits he squandered in the past. 26 years ago, as just outlined, petitioner surrendered his license equivalent to a revocation of his license. After he accepted responsibility for his actions when he engaged in a consensual sexual relationship with a former student who then eventually became a quasi-patient. Since the surrender of his license, however, petitioner has worked for the last 26 years to rehabilitate himself. He has stayed in the profession, serving as a professor of psychology at Cerritos College, until most recently changing to a professor at the Chicago College. He has it's the Chicago, he's about to testify to it, but it's the Chicago School of Psychology.
Should I clarify that?
No, we're good. Yeah. He, in addition to his professional amends, he has sought personal amends. He disclosed the relationship to his family. He disclosed the relationship to his friends, to his colleagues, accepting the embarrassment and the painful realization of what he had done openly. He engaged in both marriage counseling with his spouse as well as personal counseling on his own in order to address any underlying matters that might have led to the affair and also that might have led to him to continue the affair. He has engaged in substantial continuing education, not only through his job as a professor, but also on his own, seeking board continuing education all the way up until as most recently this past weekend, in order to stay up to date in a profession that he understands is ever-changing. And perhaps most importantly, through a combination of all of these, he has gained an insight into the matter and into himself, recognizing his errors in the past, how they occurred, and most importantly, putting in both efforts and not only that, but hard guidelines to ensure they will not be repeated. And after hearing all of that from the petitioner yourself, we will respectfully ask that his license be reinstated. Thank you.
Thank you.
All right, Dr. Gaffney, I'm going to place you under oath. Could you please raise your right hand? Do you swear or affirm under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth in this hearing today?
Yes, I do.
Okay. Now, I have this information, but I'm going to ask you to state and spell your full name for me.
Dr. Todd.
You can put your hand down.
Oh, Dr. Todd Rowe, silent W, W-R-O, Gaffney, Gaffaney.
Thank you, sir. Just one second. Okay, and Dr. Gaffney, what is your current age?
74.
Okay. Are you currently employed?
Yes, I am.
Where?
The Chicago School of Professional Psychology. I teach, or will teach, January 18th, one class, Psychopathology in Families.
Okay. How long have you been employed by, and I apologize, Ms. Johnson, I just want to get a little background information if that's okay.
It's okay. I'd
Okay.
ask it anyway.
And how long have you been employed at the Chicago School of Professional Psychology?
About 2 weeks.
Okay. And prior to that employment, where did you work?
Cerritos College, 44 years, full-time, retired in 2012, and 7 years what they classify as temporary part-time adjunct.
And you taught full-time at Cerritos College, correct?
Up to 2012, yes.
Okay. And then after that, you were a part-time adjunct?
Whatever they would have available, yes.
Okay. All right, Ms. Johnson, would you like to proceed with questioning?
I would, thank you. And we will actually take it from where the judge left off. At Cerritos, what classes did you teach when you were full-time?
Just about everything on the book. I primarily taught intro psych, abnormal psych, developmental psych, personal and social adjustment psychology. I have taught social psych, research methods, human sexuality, and the TV course, which we called our Psych 10, which is no longer in existence.
And while at Cerritos College, did you serve on any committees?
Yes, too many to name all of them. Some of the more important committees, curriculum, hiring committees. I was selected by the Human Resources Department to serve on a very difficult 2-year committee in firing one of our psychologists.
In addition to sitting on committees, were you in charge of any clubs or
Yeah.
organizations?
Yes, and I started in 1975 and immediately created the Psychology Club, which is still going to this day. And in 1980, summer of 1980, I received a letter from Carol Tracy, who was to be the executive director of SCI Beta, which was the junior cousin of SCI. In fact, her mother was the director of SCI. We started that. We were one of the original 13 chapters in 1981. That's when they officially have us on the date. And I believe I was either first in line or second in line, the vice president of the Western region when SCI Beta began, and SCI Beta is still in existence.
And does SCI Beta have a particular focus? Or an area that,
Yeah, the spoken one, and I think we try to live up to it as best we can, scholarship, research, community service, which includes volunteering in clinical different sites like Metropolitan State Mental Hospital.
at Cerritos College, did you serve as a mentor in any capacity?
Yes, there are different kinds of mentorship. We're automatically expected to be mentors for any student under any circumstances, whether they're a psych major or not, if they have a problem, particularly an academic problem. And we get a lot of that, those kinds of issues. Other mentors would be a little more involving and may involve things like helping them move on to the next division. In the last couple of years, I've taken on 8 or 9 mentees for a little more elaborate work on how to get into and help them with the process, graduate schools in psychology.
Over your time at Cerritos, approximately how many students would you say you've taught?
Five classes a semester times 60 times 44, I would guess maybe 10,000, or I know it sounds large, but I would guess maybe about 10,000.
During your time at Cerritos, were you ever brought on any disciplinary action?
No.
And what is the reason why you left Cerritos?
I left Cerritos when I received a letter July 23rd where they specified 2 education codes to terminate my contract for the following year. I was a temporary, part-time, at-will employee, and the district no longer wants my service. They cited enrollment issues, later found out through a grievance that I filed, mainly just to get clarification. There were no enrollment issues, period. There were a couple of accusations, I think, because I never was allowed to see them, so I don't even know if they were accusations, from a student or 2 students who were no longer there, was provided no input from the department, never talked to anybody, never talked to anybody from the division, never talked to anybody from academic affairs, never talked to anybody in spite of my communicating to human resources. The only thing I've received was a half-page letter citing the education codes for my termination. I got the grievance committee involved, really didn't learn anything because they don't have legal rights to challenge the education code at present. So I don't really know anything other than what I reported to you. However, even if it got all resolved tomorrow, I would not go back there. My due process rights were violated, I think.
The accusations that you learned in passing, were those related to inappropriate boundaries, or were they related to a different area?
They related strictly to a mentor-mentee relationship independent of Cerritos College. They were attending master's programs elsewhere and sought my services out to help them get into a PhD program. And for a variety of reasons, I terminated the mentor-mentee relationship once our goal of getting them into a doctorate program had been achieved. There were no boundary issues. It was a mentor-mentee relationship only, based on academic preparation like curriculum vitae, helping them with their personal statements, making contact with the admissions counselors at various schools. So that would be the only thing that I recognize, not based on anything the college provided, just based on what I think might have been involved. I've never fired anybody before, because it really, when you end something prematurely, you're really firing them. And that was very, very, very difficult. I must have had 50 or more mentees in 44 years and never fired any of them.
You were previously licensed by the board, correct?
I'm sorry.
You were previously licensed by the board?
Yes.
And what, in your opinion, caused you to lose your license back in 1993?
Well, back in 1993 was the end stage of extremely poor judgment on my part in 1985 when I got involved on my own, and even then taking full responsibility for a sexual, intimate relationship with a former student that later, a year later, I'm guessing 9 months, a year, I made the judgment of putting her into a therapy group where I have to live with the thought that the other members of that group could not have gotten a quality statement of care from me because of that violation. On a personal level, the fact that she was a former student also is a violation on my part. I violated my family, my wife, the teaching profession. It was a power relationship, and it wasn't against the law then, but it was a violation nevertheless.
When she joined your group therapy, JW, were you under the impression that she was seeking therapy services?
No, I was not.
What was
No, I was not.
what was your reason for encouraging her to join the group if you did not believe she needed therapy?
A joint decision on both our parts, but I take responsibility because it's my therapy group, to spend more time together. We had talked of marriage, and neither my wife and family, and I think, but I don't know for sure, her husband and family knew. So that was the reasoning that I best remember of something that was 33, 34 years ago.
Did JW pay for her group services with you?
No, she did not.
Did she pay for any therapy services for you?
No, she did not.
Did you ever request money from JW?
No, I did not.
Did you ever discuss money with JW?
Only to the degree that she would feel guilty that all of the lunches when we had time together were paid by me.
What caused you, or I'm sorry, strike that. When did you end the relationship with JW?
January 1st, 1988,
And-
on her porch. It was extremely difficult to do. But by that time, I was getting clear how much damage I had done to so many people, and including myself. I did it then. We had occasional phone conversations, mainly brought by her, and so I would say that was the clearest sense of it ending. I guess the last phone conversation would be the exact ending.
When was the last time, if you recall, that you saw JW?
Last time that I saw her was at the first deposition. My lawyer at the time, Pamela Kuhn Thatcher, wanted me to attend, and I saw her, but I did not speak to her.
And that deposition, was that in regards to a lawsuit?
Yes, it was.
And who was the party that initiated that lawsuit?
I'm not really sure. It had to be either JW, her husband, or both. I never knew, and I have no way of knowing for sure, but their names were on the lawsuit.
Has that lawsuit since been resolved?
The lawsuit, I think, was resolved before I guess the term revocation of my license in '93. Yes, it totally resolved.
You mentioned that you were married at the time, is that correct?
Yes, to the person I'm still married to, yes.
I guess that answers my next question.
Oh.
You're still married?
Yes, I am.
Okay. And is your wife aware of the situation with JW?
Painfully at the time, yes.
How did she become aware of the situation?
I told her.
In addition to your wife, did you share the situation with anyone else?
My entire family. Grandkids, I don't think were born then, so except one or two, and they were too young. So I excluded them with the advice of one daughter. And all my professional colleagues that I was doing therapy in, by that time, it wasn't necessary to tell anybody at Cerritos. JW had gone to the Times, and the article about our relationship was on the second page of the Times. My colleague that I team taught there was told, but she didn't even need to be told because she was aware of it all along. The president of the college was told by JW and a teacher the college later fired. The vice president of the college was told by the president and had a phone conversation with me. We both ended the conversation. We'll see what happens after the lawsuit. I have never heard from the college again in regard to that matter. And that was probably late 80s, 1980s, or early 1990s.
In hindsight,
The people change. They leave, they retire, they get replaced. So it's not hugely surprising.
in hindsight, what errors do you think you made with regard to JW?
It's almost honestly like looking at what errors didn't I make. I violated the teacher-student relationship, whether it's technical or not. To me, it's still a violation because she wasn't a student when we began, but it was a power relationship when it was a student, and I have no control if she chose to take a class again. That's one reason why those are considered power relationships in the teacher-student conduct. I had a sexual and intimate relationship, and since psychotherapy, or group therapy, was involved, that wasn't illegal back then. It is now. It was always unethical. That probably is the worst judgment or worst violation. I also, by having the relationship with her, impacted her families. It's not against the law, but it's against my moral code, and I felt it was another violation. I did it to my family. Painful as I did it. And my wife, part of the family. My colleagues, and I hurt myself.
Following your breakup with JW, did you engage in any therapy?
Yes, I did immediately.
And what therapy?
I was going to answer that. Okay. I chose Kaiser first because my wife at that time was having therapy. Not for anything wrong with her, but what was wrong with me and the impact I created for her on that. I did attend couple therapy with her very nice, great therapist. Since he's moved to Colorado, I didn't get a letter from him. I attended Kaiser one session. It lasted 20 minutes. I didn't fire him. Dr. Silverstein quit in the middle of therapy after I shared with him my story because he didn't know if he had permission to even treat me in the first place. He would get back to me after he talked to his boss. 2 weeks later, nobody got back. During that time, I read the book. I'm going to mess up the title. Sex Between Patient and Therapist, Dr. Kenneth Pope and Dr. Jacqueline Bohutsis. I made contact with Dr. Pahoutzis in Santa Monica and began therapy with her. And first couple months, great. I learned about everything from the board, lawsuits. We went over my responsibility of what I did. Around the second or third month, I was violated. She wanted me to be a poster child for some of her writings in the area of distress therapists. Now, I knew immediately, I guess the therapy was working because I knew immediately that was not okay. One thing, I wasn't getting help, and I came there to get help, not be a poster child. And two, that's a violation of my boundaries and a conflict of interest. After another month of being afraid to do anything, I finally positively ended the relationship with her and told her I needed to find, and this is true, find something closer to home. I did. Her name is Dr. Judith Jensen, and I was in therapy with her just about 2 years, with maybe a month or two off, and I did not have any problem with that. It was very corrective, very positive. I got help. My boundaries weren't violated. She didn't even tell me. I had to find out on my own that Dr. Jacqueline Pahoutzis, ethics committees, books, etc., had her license revoked by the Board of California. And why that's important is I now know from the person inside out what it's like to be violated in that way, because I felt it. Even though I was able to help myself, I felt that deeply.
What lessons did you gain from therapy with Dr. Jensen?
Well, since I had, from the very beginning, knew my responsibility was, I violated my responsibilities and judgments. Maybe the circumstances surrounding that period of time were pretty dire. I had just been developed with insulin-dependent diabetes, big shock. And my mother had died a slow death of advanced stage emphysema. By the time I saw Dr. Jensen, I had been able to put together, don't run from it. It was you that violated JW. Yes, those were stressors, but what you're supposed to do with stressors is all kinds of choices. Take time out from being a psych assistant. Talk to your supervisor. Ask for help, get therapy, any number of combinations, but those were more educational things that I would learn many, many, many times later. So we spent most of our therapy time having her help me show myself some compassion and forgiveness, and not be so toxic about what I did, at the same time emotionally and intellectually take responsibility for it too. And that's hard to do. And it took a bit of time, a couple years.
Discussing those dire circumstances that you mentioned, to use your words, have you since managed your diabetes?
My diabetes, when it's insulin dependent, can change just since I started talking. It can be that quick and so many complex variables. But bottom line, I have good control.
And if faced with a similar situation regarding the death and illness of a loved one, have you developed skills to handle that in a safe manner?
I already have.
And in what way?
A year and a half ago, give or take, my wife began to have a lot of gastrointestinal symptoms. It got progressively worse and worse and worse, even though she was seeing several doctors. Eventually, I took her to St. Jude's down here. They kept her. And in fact, they kept her for 6 weeks. She got worse and worse and worse. One way I dealt with it was a balance between being very assertive, but hopefully not aggressive, with the nursing staff and the doctors, at other times letting them do their thing and keeping my mouth shut. I talked to my kids about how I felt, because one part of managing stress is self-care. And one part of self-care is the ability to open up and allow other people to help you. I didn't have that in 1985. I have it in spades now. One of my kids couldn't deal with it. And while I didn't understand that, I allowed him to grieve, because there was a potential loss here, in his own way. And when he did involve me, I felt good, and I let it be at that. At Cerritos, I shared with every single class about 3 or 4 minutes once what I was going through, and that it might affect me. In fact, it is affecting me. And got good stuff back from them and let it go. Got positive contact from Dr. Jacqueline Ronquillo at Cerritos and Dr. Kimberly Duff at Cerritos. Ongoing positive feedback from Dr. Robert Johansson, and maybe the best feedback from my oldest daughter, who was going through a crisis herself. So we would kind of trade off. I would compartmentalize for 20 minutes and help her, and vice versa. And I was able to keep it together. There was a time that I thought she was going to die. She had given up and wouldn't even see the kids. And for my wife to not see the kids, I had never heard that before. Positive ending, 10-minute surgery, clip, 100% recovery.
The profession of psychology has obviously changed since you last held a license. Would you agree?
Absolutely, yes.
Do you believe that you have been able to keep up to date with the profession as it has changed?
Well, the 2 ways that I've kept up to date, one, I did not volunteer, and I'll explain that in a minute. My courses, not only have I kept up to date, I'm supposed to pick new books every 2 or 3 years, and that means going to Western Psychological Association Convention, an APA. At one point, I had 25 straight years at APA taking students with my wife, and she went along primarily because it's not smart to travel that far when you're diabetic. Things happen. So that APA, the WPA, course updatings on developmental, abnormal, personal adjustment, human sexuality, and I thought I was pretty well up to date. The board did not allow that. And I understand now why they didn't allow it. That's awful hard to verify and quantify. they asked me to take 36 units, and at first I thought, oh no. And I realized that everybody that's licensed as a psychologist takes that. It was a great experience. I took an advanced course in cognitive behavior therapy, even though that wasn't what I practiced back then. I took a course in cognitive behavior therapy and neuroscience with a 2-hour detour on mindfulness. And just this last weekend with my wife, because she's a marriage family therapist too, an ex-retired from last July administrator of a mental health organization. Ethics, California ethics. So those were 2 areas right there. And then I also, with a writing partner, wrote a book on relationships, which, to be honest, was kind of remedial for me because that was where I violated myself and other people. And we're finishing a book now for a professional audience on the same idea and the same thing. And that's my educational component in keeping up with what's gone on with the profession of psychotherapy.
You have discussed at length the errors that you believe you made in the past, from both your perspective and your opinion of the board's perspective. What reassurances can you offer the board that those errors will not be repeated?
34 years of being on a mission to recover, survive, and continue to grow. The education, the personal therapy, the relationship with colleagues that were there when it happened, my family, the fact that maybe this is more on my wife's end than my end. 39 years is coming up, July 25. And I think that's positive. I think that one predictor, maybe the best predictor of future behavior, is past behavior. And I've had 34 years without any character, conduct issues that I'm aware of or know of. And I think that's predictive. And I would think those are the things that I would hope that you're hearing from me.
What has caused you to wait so long to petition for the reinstatement of your license?
Well, there have been many reasons. One thing, right afterward, that wasn't a consideration. My consideration was getting help for myself. And I did, but it took a few years. My job at the time had expanded. There were more duties, more responsibilities. To have taken on a private practice then was doable, but not smart, because I was trying to balance my life. And we had a family to get together again, and there's no time limit on that kind of thing. So I chose not to. In 2012, I retired. I opened up the door to doing that because I had retired. Part-time, but that's on and off, never certain at-will employee. My wife was okay with it, but okay isn't okay. She still had some reservations. She was a little worried that the board, being public, that there would be misfirings back to her people and her job at Pacific Clinics. I wasn't going to put her through any stress on that level. To me, that would have violated my honor code, because I had caused it all in 1985, and it was March of 1985. So I didn't do it. About a year and a half ago, I opened it up again. She was getting close to retiring. She even wrote a letter on my behalf, as all of the members of my family. We decided to do it with full 100% support. We were all ready at that point in time, and that's why the long delay.
If your license is reinstated, do you know what type of practice you would hold?
What type of practice?
Is there a particular focus that you would like to practice in?
Not in terms of type of problems, but limited, because we're financially stable with my retirement, her retirement, and other investments we've made over the years. It's a kind of giving back, fee for service, that in part making up for all the time that I've lost, but that's only in part. I really want to give back in that way. I think I have talents to do that with limitations. We all have limitations, and I know mine. I don't work well with babies and children. Grandparent, but not therapist. So I think a more limited one, but again, I haven't thought too much about that, because that's putting the cart before the horse. I don't know the outcome of today. Nobody knows, on my end anyway. And if I get my license back, then I'll start seriously thinking about what to do and what kind of practice in a little more organized way.
Are you aware that if your license is reinstated, it might be on probationary terms from the board?
Yes, the investigator that interviewed me said that.
Would you be willing to, or would you abide by those terms if placed on the license by the board?
Yes, I would.
Is there anything else you'd like the board to know about your matter?
Just maybe a quick recap. I know I've probably talked too much. I want to thank you for allowing me to have this meeting. It's been 34 years, but I appreciate the opportunity to be heard. I've shared with you my sense of being responsible for everything. There's no way to dodge that. I never would, never wanted to. The improvements I think I've made in education, personal therapy, even at some cost of being violated myself once. Having the support of my family all the way through. Very positive experience in my life. I would say maybe the most positive turning point in my development. And I mean by family, my wife too. So just thank you for the opportunity to be able to share with you, regardless of the outcome.
Thank you. I have no further questions, Your Honor.
Thank you, Your Honor.
Is it possible to have a break? Just a tiny break? Restroom break?
Is it okay for you if we go?
Absolutely, yes.
Yeah, just need
Is this a
quick
break
one.
time?
Yeah, sorry.
Back on the record after the break. Dr. Gaffney, do you understand you're still under oath to tell the truth?
Yes.
Okay,
Oh. Yes.
thank you. All right, cross-examination.
Thank you, Your Honor. Good afternoon, Dr. Gaffney.
Good afternoon.
Dr. Gaffney, before you is a binder of exhibits. What I'd like you to do is turn to Exhibit 4, AGO 28, and you'll see that marking on the bottom right-hand side.
Word, not sure where to turn. Oh, 28. Yes.
Okay, I'm gonna focus you to the first paragraph of this page, and incidentally, just by way of background, this is your written statements to questions that you submitted as part of your petition, correct?
Yes.
And specifically, this is in response to question 1 of the disciplinary action information sheet that you were asked to complete as part of your petition, correct?
Yes.
So let me focus you to count about 12 lines down from the top of that paragraph. The sentence begins, "I began a consensual relationship." Do you see that place?
Not yet. 1, 2, 3. Yes, I see it now.
Okay, I want to read your statement for the record because I do have some follow-up questions for you regarding what you've stated.
How many lines do you want me to read?
I will do it, sir.
Oh, okay. I'm sorry.
Just hold me accountable and make sure I'm reading it correctly, okay?
Yes.
It says, quote, "I began a consensual relationship with my student, JW, and we began to use therapy as a cover to hide the relationship. JW never paid for my services nor received actual treatment and never indicated she desired treatment from me." You go on to say, "Regardless of whether treatment was provided or not, I breached serious ethical bounds by being involved with a student and using a profession that I honor so greatly as a cover to continue an affair." Did I read that correctly?
Yes, it's incomplete, but you read it correctly.
Okay, good. So I'd like you to turn to AGO page 30, same exhibit. And this time you're responding to the question number 3, and the question is, was it your behaviors that led to discipline? I want to point you, I'll wait till you get there.
I'm missing 4.
So you should be on page AGO 30.
He's missing page 30 in his binder.
There is no page 4.
Can you give him yours?
Yeah.
Okay.
So you have AGO 30 in front of you now, sir?
Yes.
And looking at your response to question 3, the second sentence, first line begins, "Regardless of any discussion of consent, whether or not therapy was provided, and any lack of payments, I should never have engaged in a relationship with a student and never used this profession to help further my affair." Did I read that correctly?
Let me read that. Accurate, but incomplete.
These are your words, sir? No?
Yes.
Okay, so I'm reading just that sentence. Okay.
Right.
Did I read that sentence correctly?
Yes.
Thank you. So based on those statements that you've made in your petition, sir, is it your understanding that the unprofessional conduct that led to your loss of license was that you had an extramarital affair with a student and that you used therapy as a cover?
Not at all. No.
What is your understanding of what
My-
led the unprofessional conduct that led to your loss of license?
In terms of the Board of California loss of license having a sexual, intimate relationship with someone, JW, that at some point I allowed to go into group psychotherapy, and that was the basis for that part of it having to do with the license. The other things that I said had more to do with her role as a previous student, and the power relationship that always is introduced in that kind of thing. So it was really a confluence of a lot of different things, but the part relating to the license, I had her, took responsibility for putting her in the group psychotherapy. The second year is my best estimate of our relationship, and that was the violation as far as license and board goes, with other violations previous to that on different grounds not involving license.
So you agree that the unprofessional conduct was that you had engaged in a sexual relationship with a patient during the course of a therapist-patient relationship. Is that correct?
That is correct, yes.
Why do you not refer to her in your petition as your patient? You would consistently refer to her as your student.
Because it was the second year, approximately, that I allowed her to join the group, and the violations up to then were more having to do with families and the education code prior to her being in group psychotherapy.
You also state, sir, that JW never paid you for treatment. Is that correct?
Never what?
Paid you for treatment.
Not only did she never pay me for treatment, to the best of my knowledge and memory of something not long ago, we never thought this as therapy prior to her being placed in the group therapy. We used my therapy office as a place to meet and hide, not the act of therapy that first year. Technically, it doesn't matter in my mind because the second year I did, and that's the licensing part, and that's as accurate as my memory allows it to make it, at least from my point of view.
But isn't it true, sir, that you admitted as part of your stipulation to resolve your accusation that you entered into what is essentially a therapy for services arrangement with JW?
Well, the second year would account for that, but there were no fees for services, period, under any circumstances ever.
That's not what I asked you, though.
I thought that was part of it.
Didn't you say that she could pay you by being a facilitator for your human sexuality, Psych 33 courses, by acting as an officer of SCI Beta, and by helping with other projects?
No, I did not.
Okay,
I want to add to that.
That's fine, sir. Let me just direct you first to Exhibit 3, page 16. So if you look at subparagraph F, it states, in or about April 1985, during another therapy session, JW discussed the issue of payment. Respondent later told JW and her husband that JW could pay him by being a facilitator for his human sexuality and Psych 33 courses, by acting as an officer of SCI Beta, and by helping with other projects. Respondent told JW's husband that this type of arrangement was common. Do you see that?
Yes, I do.
And if you flip to a few pages earlier, which is AGO 9, remembering that that's subparagraph F of paragraph 6.
Number 3.
AGO 9. Paragraph 11 is where you, as part of your stipulation, admit to certain allegations and deny certain allegations. And one of the things that you admit to is paragraph 6F. Do you see that?
Not yet. I'm looking.
It says, respondent, having the benefit of counsel, hereby freely, knowingly, and intelligently admits to the allegations contained in paragraph 6, and it goes on A, B, C, E, and F.
Yes, I see that written.
Okay, so sir, having seen that now, isn't it true that you admitted into entering into a therapy for services arrangement with JW as part of your stipulation to resolve your accusation?
What it means in my mind, going back in time, was that JW told her husband, because he thought that we were doing therapy as a means of having time with her, that she was being a member of the Psych Club, an officer of the Psych Club, and facilitating as a common way to barter or trade for fee. That was what she told her husband, and that's 100% true. And I would not have anything to gain by having her a member of SCI Beta. She would have things to gain by being a member. So that's how I remember it back then. If there was a jump to saying yes to F and no to B, C, and D at that time, I was very distressed, and it would have been an error of omission because of being distressed, even though I had legal counsel.
So
I'm
you're
asked to clarify now, having recovered quite a bit, to the best of my memory and the best of my recognition, and that is what I've shared with you as best I can.
So you're saying, sir, that as you sit here now with the benefit of hindsight and recovering from what happened, you take back your admission to paragraph 6F?
Let me read it again. F. Only to the degree that it was JW that talked to her husband, I had not even met him yet. And no, none of this resolves me of violating the license part, because I was a registered psychology assistant when I put her in the group. The fact that there was no fee has no impact on me whether I thought that was a violation or not. Yes, it was a violation.
So, sir, to the extent this paragraph is true, it's true only because the arrangement that's being discussed therein was JW's doing, not yours. Is that what you're saying?
Partly. It
Okay.
was not only JW doing it, I had nothing to gain by having her get the benefit of being in the psychology club.
Sir, one of the other paragraphs or allegations that you admitted to as part of your stipulation was 6K. And I'd like you to turn to page 17, where it sets forth the allegation for 6K.
What exhibit are we in?
AGO 17.
I know, but what exhibit?
Same exhibit.
3? 17. Oh. We're looking at what?
Paragraph K.
K?
Yes, and paragraph K, you had admitted that, quote, during the summer of 1985, J.W. acted as a facilitator for respondent's summer course. Respondent told J.W. he wanted her to do this so that the two of them could be together over the summer, and so that J.W.'s husband could see that J.W. was fulfilling her end of the payment agreement. Do you see that?
Yes.
And you admitted to the truth of that allegation as you sit here today. Is that still true?
No.
Why?
What I admit to 1, 2, 3, 4 lines, but now that I look at it with hindsight and not distressed, the last part is not accurate because J.W.'s husband could see that J.W. was feeling that would have been her doing that, not myself. I can't even say for sure if I even had met him at that point.
And so as far as that paragraph goes, to the extent that it's true, it's only true because it was J.W.'s doing, not yours.
No, it's also true in that the summer facilitation thing in itself was isolated from and having nothing to do with psychotherapy.
But reading this particular paragraph, sir, in terms of the part that you take exception to, in other words, the part that you say now that you do not admit is that you had some role in the payment agreement that was entered into between you and J.W. In other words, you're saying that it was her doing, to the extent that there was a payment agreement, it was her doing, not yours.
That part is true, yes.
Sir, you also state that she never actually received treatment from you. But isn't it true that you admitted as part of your stipulation that you provided therapy to J.W. as part of your stipulated agreement?
I also admitted it here because I put her in a psychotherapy group. I don't consider that not therapy because I did not charge her. That is what I admitted to here as far as the license part. I also admitted other parts in the teacher-student relationship that I had deep feelings and regret about and took responsibility for. Her being in a group therapy constituted therapy, and there were no fee for services with her.
Didn't you also provide her with individual therapy?
No, I did not.
But if you look back at your accusation and what you admitted to, again, I'll represent to you that you admitted to paragraph 6A. 6A,
What page are we on
excuse me,
now?
not 6A, but 6C. And if you look at paragraph 6C on AGO 15,
I think, here it is. I'm on 15. What paragraph?
C. It says, in or about February or March 1985, J.W. began therapy with respondent at his private practice office. That's not alleging that you began that she was in group therapy with you. That's alleging that she began therapy with you. Isn't that correct?
It's correct. As I read it now, that's exactly what she told her husband we used the therapy office as a hideout office at that time. Could I be wrong in thinking that any discussion that we would have during our time together, like any couple does, she could construe that as therapy because I'm a registered psychological intern? I didn't think so at the time. I don't know so now, but it is definitely possible. Was I thinking of her in that way at that time as doing therapy? No, I was thinking as a intimate partner, period, at that period of time.
But that paragraph doesn't say that you commenced an intimate relationship with her at your private office. It says that you began therapy with her. Don't you agree?
That's what that paragraph says now, after all this time of looking at it a second time from fresh eyes, not overwhelmed with guilt, responsibility, and stress. When I reviewed it with Pamela Thatcher, my lawyer at the time, yes.
So is it your position, sir, that now, with the benefit of hindsight and the lack of distress, that that paragraph 6C, you do not admit to?
I don't see anything in the paragraph yet about individual therapy. What I see is a general statement of what I've already admitted to multiple times about placing her in a psychotherapy group and for all practical purposes doing therapy, but not fee for service. I'm not going to admit to something that didn't happen. And I don't see anything in that paragraph about individual therapy. I do remember from that paragraph that was what she told her husband to be able to have time with me. Did she ever talk about that with me? I honestly don't remember, but presumably, possibly she had. So I would have been aware of that and complicit in lying to her husband too, but that's different than doing individual therapy and charging fee for service by some kind of trade bargain that I would not possibly even gain by, even if I did do that, and I didn't.
So, sir, it's your position that in February or March of 1985, and in addition to that, during no time period did you ever provide individual therapy to JW?
I cannot think of a single instance in how I would conceive of psychotherapy, and I have to look at it from the lens of being back then as a psychology assistant with limited but not complete education, did I think of her in that way. I thought of her as an intimate relationship that does not answer the question on the second year. I did intentionally, with her consent, but intentionally put her in a psychotherapy group, and in my mind, to the best that I remember, that is where the violation of my either registration or license, because I can't remember the time frame, could have been licensed then, took place, but that doesn't resolve me for all the other things that I talked about, and I did admit to doing that in the group therapy, whether fee was involved or not, and I remember no fee under any circumstances ever.
I would ask you, sir, to turn to page 9.
Page 9.
Same exhibit, page 9.
It's AGO, not page.
I'm lost.
You mean AGO 9, right?
No.
Not page. Okay.
So again, turning to paragraph 11, there are certain paragraphs within your accusation that you denied. One of them you'll see is 6J. Do you see that, sir?
I don't see 6, but we're on page, it's in the paragraph. Okay.
Correct,
6,
yes.
6J, yes. I
And
don't know
at
whether.
line 22, it says respondent denies the allegations in paragraph 6D and 6J. Do you see that?
6D and 6J, yes, I do.
Okay, now I'd like you to turn to page 17, AGO 17. And I want you to look at paragraph J.
I'm not used to this, and I don't know where, here's, at 17, you said?
Yes, paragraph J. Take your time.
Paragraph J.
Paragraph J says,
Okay, yes.
it says, in or about June 1985, JW started attending respondents' group sessions at affiliated counselors. So here, you denied as part of your stipulation that she attended your group sessions, but now you're saying, sir, that you do accept responsibility for the fact that you had her join your group therapy sessions?
Well, reading the statement in J now would not be accurate. It would have been June, I don't even know the month. It would have been a month in 1986. But apart from the year, she did attend group sessions, which is group psychotherapy, at affiliated counselors. I'm not even sure that's accurate. There may have been there was a different location in Downey, and I don't think they were called that then. So I can't verify that name, and I don't think it was 1985. I think it was 1986. It was about a year after that. But to me, that's a minor point. She did attend group therapy sessions, yes. There just was not fee for service.
You keep saying fee for service. Why is it important to you that she paid you a fee in order to be your patient?
It isn't. What's important to me is that you were asking me to comment on that while money wasn't exchanged, barter or trade was, and that is what I was commenting on. I made numerous attempts to share that, yes, putting her in group psychotherapy and no fee is therapy, and I took responsibility for that and am taking responsibility for that.
If you turn to paragraph 6D, which is page AGO 15.
Yes.
So that paragraph is a paragraph that you denied. And it
What
said,
paragraph are we looking at?
D. It says, in or about March 1985, when JW was leaving her session with respondent at his private practice, respondent kissed JW on the cheek. You denied that. What's your position on that allegation now? Do you still deny it?
Oh, I'm reading it right now.
Let me know when you're done.
Okay. Well, the session word to me implies or could imply psychotherapy. Sitting in an office and spending time together and talking was what I accurately remember. So I was probably, when I questioned that, focusing on the word session. But again, that's 34 years ago. To remember back why I didn't like that, that would just be a guess now about then because of that single word. Not an avoidance of personal responsibility of at some point putting her in a group psychotherapy.
So
I've never avoided that.
So as you sit here today, your issue with that paragraph is the word session because it's your position.
I'm guessing because I don't know 34, well, I guess 26 years ago, because this was 93, exactly what I was thinking at that time, only partly because of being distressed, but also that's a long time ago, and I'm looking at it now for a particular word in why I might have objected. I did not object to taking responsibility for doing group psychotherapy with her, which is psychotherapy.
I'm not asking you if you object to this paragraph. I'm asking you if you, having read it now, do you admit to it or do you still deny it?
I admit to neither. I admit to kissing her on the cheek. I admit to having this done in a private practice office. I do not understand and will commit to the word session because it implies in my mind now doing psychotherapy at that time. It's the time thing that I'm focusing on. 85 as opposed to group psychotherapy in 86.
How long was your relationship with her during which you had sexual relations?
March 1985 to December 86, or it about 19 months. I'm not 100% sure of the exact years that far back. I am pretty clear on the chronology of what took place, just not exactly positive about 85, 86, 87, etc., but about 19 months.
So I want to turn now to, I want you to turn to Exhibit 4, page AGO 32. Here you're asked about assurances that you can provide to the board that you'll not reoffend. This is in response to question 7. And looking at the first full paragraph on page 32, you discuss there your career at Cerritos College, that you were a professor, that you were a founder of the Psychology Club and co-advisor of SCI Beta, that you had traveled annually with students to the American Psychological Association Convention, a lot of things that you discussed earlier today. And if you look at line 9, it says, quote, "This work has all been conducted with Cerritos' full knowledge of my past and my discipline." Do you see that?
This work has all been conducted with Cerritos' full knowledge of my past and my discipline. Yes, I read it.
Great. And now I want you to turn back to AGO 27. This is your narrative statement that you submitted along with your petition, correct?
Mm-hmm, yes.
And if you look at first full paragraph, line 10, it's actually the second to last sentence in that paragraph. You say that your time there, speaking about Cerritos, has been possible due to the strong support Cerritos has provided me despite its full awareness of my circumstances. Do you see that?
Yes.
And then on same page 27, next paragraph, you start talking about the numerous letters of support that have been provided to you and that you submitted as part of your petition. And at the 7th line of that paragraph, you state, quote, "I hope these words, offered with a full understanding of the circumstances, help form a comprehensive picture of the person I am today and the life I have built following my discipline." Do you see that?
Yes, I do.
Sir, when you asked Dr. Ronquillo and Dr. Duff to submit letters of support on your behalf, you did not disclose your past misconduct to them. Is that right?
In the case of Dr. Ronquillo, no, on advice from my family. And in the case of Dr. Duff, I think on occasion she knew much of it, but not all of it, because of my conversation with her in New Orleans maybe a decade before. And to the best of my recognition and knowledge of the letters that I submitted, all of them but 2 were told the entire circumstances, ad nauseum, in fact.
And
What I said, and I like to, what I said to the investigator, my family did not want me to tell Dr. Duff and Dr. Ronquillo, because too many people were knowing that didn't have any stake in my license in the first place. The board criteria that I had was that most of the statements be told the entire full circumstances.
where did you get that direction?
Well, from the paperwork that asked for letters of comments, that criteria was something most should require that. The reason I didn't at Cerritos, it was decades before they got there, number one, and number two, I didn't want that kind of recommendation from them. It was very clear. I wanted a recommendation from the time they knew me, decades later, academic performance or competence and my ability to relate reasonably with students. That is what I asked for. That was what I asked Dr. Ronquillo for. I know that there was never an unclear part to Dr. Duff about that. And in terms of the previous stuff you had me read, the school did know immediately when there was a lawsuit. The Times, J.W. talking to the president of the college, which I was informed of, my conversation with Dean Page, but the accuracy needs to be put in the context that these people are dead now. They've died a long time ago. New people have replaced them, and new people have replaced them. And it is true, and if you need me to say this, I take personal responsibility for every new hire, and there's been so many in 44 years, of not going through all the circumstances that were at one time on record. So that I would admit to is a failing on my part, if that is a legal requirement or something that maybe I should have done. The reasons I just gave you, or why I didn't talk to Dr. Duff Foley, although partly I had, and Dr. Ronquillo et al. Was my family's guidance on that, and not necessarily mine. I was telling too many people who didn't have any reason to know anything about it, almost like, I wasn't putting enough smart restraint on justifiable reasons why someone should know that or shouldn't know that.
Did you ask your family for permission to tell them? And by them, I mean Dr. Ronquillo and Dr. Duff?
Many times, many times, many times.
And this was in connection with telling them that you were going to ask them to write a letter of support on your behalf.
Long
correct?
before that.
Well, I'm asking about the time frame when you were getting your petition together, assembling letters from people to submit on your behalf. You identified two people, Dr. Duff and Dr. Ronquillo. At that moment in time, did you ask permission to your family to disclose your past misconduct to them, knowing that their letter of support would be for your petition for reinstating your license from revocation that happened based on your past misconduct?
Yes, I did, and I put it in the context that what I was after from Dr. Ronquillo and Dr. Duff was only two criteria, and I spelled that out with both of them: academic competence and character with students from the time they came aboard, and the reason why they were picked was they at different times had been the department chair. My view of that was a letter of recommendation, period, not a review of my entire case history that related to the sexual conduct that other professionals commented on, numerous, and all family members knew about. And yes, on many occasions before this documents were being gathered, my family did not want me to tell them that. And yes, just before that document was put together, we discussed it, and yes, that was the outcome of what they wanted to do, absolutely, positively, for sure.
They who? Your family or
Three
Dr.
kids, one wife.
Okay. So you're saying that your family dictated your ultimate submission of these letters?
No, I didn't. I said my three kids and my wife gave input from their point of view and their feelings about Dr. Duff and Dr. Ronquillo. No one else. And I made the decision, not my wife and family. They were my consultants. The basis of my decision was that it was more important for me not to violate their wishes than the mistrust potentially of Dr. Ronquillo, which could be discussed with me if it ever came up. I would be glad to discuss it, and yes, then it would come out under those circumstances.
Was Dr. Ronquillo upset with you about you not disclosing to her your past misconduct when you asked her to write this letter?
Dr. Ronquillo has not talked to me about that matter under any circumstances ever, and we had, up until I left for summer vacation, on the surface at least, and certainly from my end, a very positive relationship, including attending a banquet that we had for SCI Beta candidates, attendance at WPA and listening to my presentation on the history of SCI Beta. There was no comment, written, verbal, or otherwise, that would indicate anything to the contrary. Ever.
When was the last time you talked with her?
In an email, because they made a mistake about a single class. There was a glitch. I emailed her about that. and I think and hope in a professional kind of way, alerted her to the problem. She responded back by saying, thank you, the problem is corrected. And that was the last time I've spoken with her, and that was approximately June of this year.
I'd like you to turn to Exhibit 5, AGO 42. Exhibit 5 is the investigation report that was prepared in connection with your petition. It was prepared by the investigator with whom you also had an interview with. This page summarizes her telephone interview with Dr. Ranquillo, and if you that occurred on June 20th, 2019. If you look at the second paragraph, she discusses Dr. Ranquillo's reaction. She summarizes, the investigator summarizes her discussion with Dr. Ranquillo, and she says that Dr. Ranquillo, expressed when Gaffney asked her to write the letter, he did not disclose the circumstances of his license surrender. She stated his failure to inform her of his misconduct felt like a breach of trust. Do you see that?
I've said it, and I see it now, and I've read it many times, yes.
And then the next page over is page 43. The summary goes on to state, quote, Dr. Ranquillo stated had she known about Gaffney's misconduct, she would have declined to write a letter supporting the reinstatement of his license. Do you see that?
Yes, I do.
What's your reaction to Dr. Ranquillo's position?
I have no idea, because I've not talked to her, to know it fully. I can react to the statement made here that she felt like her trust was violated. I can see it from her point of view, and I would have felt like I violated my trust of what my family wanted me to do at the same time. This is the kind of thing, and one reason I love psychology so much, two people getting together and talking about what they felt violated about, and resolving their differences in a positive way. I have never had any contact with her about this. She has never mentioned this to me in any way whatsoever at all. And it also says in that same paragraph that while she wouldn't have written it if she had known, which is conjecture because she wasn't told from my point of view, and she said the letter that I wrote him would have stayed the same, I just wouldn't have written it because it was accurate.
So if you could do it again, sir, would you disclose your prior misconduct to Dr. Ranquillo and Dr. Duff?
No, I would have left Dr. Ranquillo out of it because it evidently has hurt her very much, and I don't want to hurt people. Knowing this ahead of time, or if somehow I had that magic ability, I would have talked to Dr. Duff, and I think I would have taken her out to dinner with my family, and we've all would have talked about our issues and why I did what I did, and I hadn't told her before, and then ask her permission to do that. That I have the courage to do that. Every mentee that I have worked with, other than transient coming into the office, I have spent an hour of their time, approximately, telling them the full story of my sexual, intimate, scandal violations in 1985. One wrote a letter knowing that. I didn't think I even read her letter after it was written, so I don't know for sure, but she was told that. And so it was not a reluctance on my part to tell them. It was a reluctance on my part because I was not after that kind of information. I did not know you used an investigator to talk to the people after the fact. I had no way of knowing that. I've never gone through this before. When I found that out, and when I did talk to the investigator who met with Dr. Ronquillo before she met with me, I told her, the investigator, Ms. Walker, that why I did what I did with Dr. Ronquillo and Dr. Duff, and my justification for it. But in terms of your situation, knowing its impact on Dr. Ronquillo and my strong feelings, because I care about Dr. Ronquillo, I helped hire her. She was a student of mine at one time, and I helped her on a medical issue that I can't go into because of privacy. So I care about her very much. I would have handled it differently with the two of them, but I did not know that, and I weighed heavily my family's feelings about it at the time.
Dr. Ronquillo is the head of the Department of Psychology at Cerritos College, correct?
Currently.
Currently. And she is also a professor at Cerritos College, correct?
Yes, she is.
And likewise, Dr. Kimberly Duff is also a professor at Cerritos College, right?
And has been the chair of the department even for a longer period of time than Dr. Ronquillo.
So, sir, is it fair to say that your statement in your petition that Cerritos College had, quote, full knowledge of my past and my discipline, end quote, is not true?
No, it means that when I made that statement, it was true in 1985 or 86 for several years, maybe even a decade, while those administrators and faculty were alive and taught there. Did I update every decade of new administrators? No, I did not. But I admitted that too.
But your statement about their full knowledge was made when you submitted your petition, correct? We're not talking about years ago. We're talking about when you submitted your petition.
That's correct. They have a record of that. I don't know how much pre-computer 85 was. I'm kind of late to that, so I would assume there's written records from President Gaston to J.W., Dean Page, and a phone conversation with me, Connie Mance, multiple conversations about it during that period of time. I don't know that as a fact. I've never seen collaboration of written records. I'm assuming that and inferring that because that would be a reasonable thing to do over something as large an issue as that.
You mentioned something earlier about a couple of accusations that were lodged by two students at Cerritos against you. And you also talked about a mentor-mentee relationship that you had with these students. I want to try to get a better understanding of what happened. You indicated earlier that that relationship had been terminated. Who terminated it?
There were two. I did both.
And why did you terminate it?
Each one is very different, and the histories are very different, even though they were on the same research project. In the case of, I need a answer to a question. Am I allowed to say their names?
No, I think you can refer to them as Student 1 and Student 2.
Okay. Student 1, I'd worked with over a year. Our work was essentially done. I did everything that I could, everything I possibly could to help her get in a position to at least be interviewed for the doctorate program. I can't honestly remember a time of weekly meetings when she was not 20 minutes late or later or on time. so many missed meetings, even up to the end, not doing anything, any work whatsoever on a research project I allowed her to take part in because I needed help doing the research. I had other team members doing it, and they were doing a great job. And in my view, she was jeopardizing that. At one point in December, I left the mentor-mentee relationship. In all honesty, there wasn't anything left to do, and allowed her to stay on the research project. And after a couple more misses and my project getting very shaky, I fired her from that as well. And it tore me up to do that. I'd never fired anybody before, and I know it was going to hurt her. And did I handle the ending as good as I could? I think I did in part, and I didn't in other parts. Endings are really hard. And I didn't foresee, how difficult this would be for her too.
Why do you
Doctor, I'm getting to the student number, not student, mentee number 2.
And
These
before-
aren't students.
Okay, well, before you get to mentee number 2,
Yes.
with respect to mentee number 1, why do you think she filed an accusation against you?
I know of no accusation against me from mentee number 1. If there is one, no one ever told me. I was never informed. I have no input from anybody on any level at the college of anything of that nature at all.
Was an accusation filed against you with respect to mentee number 2?
Not that I am aware of. Not that anybody has told me.
You said earlier that you had found out later that a couple of accusations from 2 students had been lodged against you.
That wouldn't
did you
be
misspeak?
accurate, no.
Mhm.
That wouldn't be accurate.
What was it, complaints?
I have no idea. In the termination letter from HR, there was a 2 or 3 line part in a 4 or 5 paragraph short letter indicating the word complaints from students who mentee number 1 and mentee number 2 were not students. Not by 2 years. They were students somewhere, but not at Cerritos College. And I was given no information about what the complaints were, if there were any. I was given no information that there were even existed and from whom. Some of that, in guessing from whom, is an inference, because I don't know of any. I was never contacted. I mean, on any level. Even in the letter, it wasn't clear. And in the letter that, what Dr. Ron Keel said was back in March 19th, there was some kind of complaint that I was never informed about, and that's not the protocol at Cerritos College. And it went to student services, and the interpretation of it was inconclusive, which I don't even know what that means. As a professor at the college, we all get, and I mean everybody down the line, complaints about grades. And we even encourage it because the student should stand up for what they think might be an error in their grade, and sometimes there are. I have made errors. But as a character complaint, I don't have any facts from any person at Cerritos College during any usable period of memory of such a complaint at all, other than a vague mention in the termination letter from HR, who didn't respond to it in any other detail.
What were the circumstances with respect to mentee number 2?
Because of the real difficulty of firing someone, these things bother me. I don't like to do it. I wouldn't have done it if I could have done it any other way. My blood sugars were temporarily off during that 2-week period of time. I did what I thought I needed to do personally to take care of myself, and I did it the best that I could. I did it to protect the research team, and I pretty much achieved my reason for being with mentee number 1. And mentee number 2 probably wouldn't have let her go, except by the time, and they were kind of coalesced in terms of about the same time frame, and they worked on the research together. I wasn't. I needed to take care of myself and not extend myself further with a mentee relationship that had pretty much achieved its purpose. How well I communicated that to mentee number 2, looking back on it, maybe I could have done a better job and a more sensitive job of how my health was beginning to crumble, and it's important for me to take care of myself. I think I did do that to some degree. I just don't know how well I did it, and if those are the people involved, and I don't know that they are, because I was never given that information, then I needed to have done a better job ending the relationship that I did need to end.
You talked earlier about how you deal now with stressors. And one of the things that you said is self-care, which includes opening up and allowing people to help you, correct?
Selectively, yes. Just allowing anybody, anywhere to help, I don't consider that self-care. Putting some intelligence behind it, yes, then I would agree with you completely.
So the fact that you withheld material information from Dr. Ronquillo and Dr. Duff about your past, does it give you pause about your ability to truly open up to others, share your stresses, ask for help?
No, it does not, because I have all family members going back to 1985 and continuing up to including a week ago, talked about it openly. My wife included in the word family, colleagues starting back in 1985, and a continuous pattern of opening up and sharing, including weekly, maybe even 3 times a week with Dr. Ronquillo during some parts of my therapy process, along with my wife. So I think that kind of testifies that I can allow that. 2 people, actually 1.5, because I already shared some with Dr. Duff. And I stated that a little while ago. Dr. Ronquillo mainly, and there are more reasons I would be reluctant to do that with her, having absolutely nothing to do with the licensing board. I just haven't chose to go in and share that because it didn't bear on this. I didn't think. But She is the one exception, maybe a half to Dr. Duff, when I never went in with that frame of reference in the first place. I wanted a letter of recommendation.
How long had you known Dr. Duff?
1999.
A long time.
Yes, I have.
You consider her your friend as well?
Yes.
And how long had you known Dr. Ranquillo?
Well, I knew her, but didn't know her as a student in my abnormal psych class. We joked that it was the only class that she ever fell asleep on, and chose not to go into clinical psychology, but statistics, quantitative psych. But I didn't really know her then. She was part-time, and we shared an office for 2 or 3 years, probably longer, and I was on her hiring committee when she was hired.
So when would have been the first year that you interacted with her?
Well, when she was a student, and I can't tell you because it was 20, 25 years ago, maybe.
Let me clarify, as a professor.
Well, I was a professor then.
As a professor, how long had you known her?
Oh, when she was a professor. Well, if Dr. Duff was 99, I'm thinking she was about 2009, 2010 would be my best guess.
So in the professorial capacity, you've known her for about 10 years.
I'm sorry?
So in the professorial capacity, you've known her for about 10 years.
Yes, I think, I don't know if she would agree, but I think I provided some mentorship of her during that time. I think I played a part in asking her, as one of the co-advisors of SCI Beta, to join Dr. Duff and myself. And certainly we shared a personal relationship at the office to a certain degree, and I was able to help her in some private, confidential medical things that she was going through. So there was more than just a professorial type of thing.
You stated that you told Dr. Duff over the years some of what happened in the past, but not all of it. So what did you tell her?
That I had had a relationship with a student that she already knew, and she said that I had already gone on Rate My Professor, and it was all there. My name was there for 10 years, so she knew part of it. How much exactly she knew many years ago that I had shared part of it, I don't remember because I didn't know I would have to, testify in that, but parts of it. And my wife was there at the time.
And you said this was during the New Orleans conference that you both attended, correct?
Correct.
And when was that?
I don't remember. The 25 years of conferences, it would have been full-time, so it would have been before 2012. I would say maybe Dr. Duff came on in 1999, somewhere early 2000 would be my best guess.
Early 2000 is when that conference would have happened where you had this discussion with her?
Yes.
Okay. So since early...
Well, no, I'm not saying that with full memory and knowledge that I could be off 4 or 5 years.
Your best recollection.
Yes.
So since early 2000, had you had any subsequent conversations with Dr. Duff about your past misconduct, including what led up to your discipline from the board?
Not that I'm aware of, no.
Sir, you have talked about Dr. Judith Jensen. She actually submitted a therapy information sheet as part of your petition, and in there she discusses having had provided you therapy between 1993 and 1995. What's your therapy regimen now?
My what?
Therapy regimen. Are you undergoing therapy? Are you having therapy?
I am not currently having psychotherapy, no.
When was the last time that you have had therapy?
Formal therapy, 1995, with Dr. Judith Jensen. I think those are accurate dates.
Do you have any plans for doing therapy going forward?
I'm not sure what you mean by that sentence. Me undertaking therapy for myself, you mean?
Yes, not providing therapy, but you being a patient undergoing therapy.
I have no formal plans. I'm never against it. I would never want to go back and do it if I didn't believe that it did good. And if it does good, it would be good for me as well, even if there's not a single pressing need. I have no restrictions or negativity about that at all.
As part of your petition, you submitted certificates of CE courses relating to the field of psychology that you completed in 2019, and that's at Exhibit 23. Am I correct to say that you completed those?
Well, I got to look.
Sure.
I don't want to agree to something I didn't. Yes, and I already made an error. I said advanced cognitive behavior therapy. I don't know if it was advanced or not. It was cognitive behavior therapy for 3 days.
Can you look through that exhibit, sir? And I just want to ask you this. Are those CE courses that you took in 2019?
Yes.
And if I understand your testimony earlier, it sounds like you had a discussion with the board, and the board had requested that you take 36 units of CE. Is that correct?
The information was relayed to me by Lindsay Johnson, my attorney, that the board wanted that. I did not know if they disavowed what I had put in as previous education. I didn't know one way or the other, but I was certainly going to comply with that, and eventually got around it and saw it really as a great thing.
And so you took those courses.
Yes, I did.
Let me finish. You took those courses in order to satisfy what you believed to be something that the board wanted you to do.
Yes.
I want you to turn to Exhibit 25, AGO 132.
Yes.
You wrote a letter to the investigator for the board, essentially summarizing to her some additional CE courses that you completed in 2019. Do you see that?
Yeah, the second paragraph, right?
Yes. And in fact, one of those CEs that you completed was an ethics CE course that we have as one of the exhibits in our petition, Exhibit 27, correct?
No, that wouldn't be correct. The ethics course that I was currently taking at the time didn't really, it was an online thing, and it wasn't really very good. And one came up after that I completed in person, which I get more out of. So that just wasn't up to date, that part about the ethics.
And that's the certification that you provided today and
Yes.
that we have as Exhibit 27.
Yes. And the board never asked for that. That was voluntary on my own.
Sir,
I have a problem. I need to use the restroom, and I would like a 5-minute timeout.
you can
with
have that.
permission.
You
Thank
can have
you.
that timeout.
We'll go on break for 5 minutes with all. I know that. Sorry, I'm hoping that, it's 4:14. I'm hoping that we can wrap this up relatively quickly. I want to give everyone a chance to ask questions, okay? So we'll go off the record for 5 minutes. Dr. Gaffney, you understand this still under oath to tell the truth?
Yes, I do.
Okay, Ms. Lizon?
Sir, did you take any CE courses in 2017?
2017?
Correct.
No, just 2019. I don't think, but I'm not 100% sure, if I took CE courses when I first got licensed, I'm not sure their requirement was anything like that then. But no, I did not in 2017. Sorry for the delay.
No problem. So setting aside those CE courses that you possibly took when you first got your license and those that you took in 2019, you have not taken and completed CE courses relating to psychology, correct?
Oh, no, not correct. There have been many conferences that I attended the CE coursework with, but I wasn't licensed then. I wasn't in the process of getting relicensed. I just took them for educational purposes, and many times they help augment new ways of thinking about parts of my courses that I taught. So, but the board wouldn't have counted that because I didn't have verification of that. So that was just stuff that I've done in 25 straight years of going to APA.
You took courses, but you don't have certifications to demonstrate that you took those courses. Is that correct?
Correct.
And the last time you were in a clinical setting was in the 1992-1993 timeframe. Is that correct?
Clinical setting?
Providing therapy to patients?
Would have been some months in 1993 because that was a revocation of my license. My therapy was curtailing up to that point so that I had proper time to terminate the clients in a reasonable period of time and as carrying away as I could. And by the way, most of those clients did know why I was doing what I was doing up to a point that it made sense to tell them.
And since
No therapy
since
at
then,
all.
you have had no patient contact.
No patient contact whatsoever. And like any member of a college, whether you're a psychologist or not, students would come down, need help. I would make the proper referrals either out into the community, where I had a lot of resources, or to the campus counseling center itself, in conjunction with what everybody else does there, because there's a need.
Thank you, Doctor. Those are all the questions that I have.
Johnson, any redirect, and again, I caution you, I want to leave time for the board. If you
I'll be
can.
very brief. I have
Thank you.
4, maybe 5 questions. I think they're short. Dr. Gaffney, do you admit that there was cause for your license to be revoked?
Absolutely. Many times. It just, in my mind, wasn't individual therapy, it was group therapy, and that's a technical point. Therapy was done. I was responsible for it. I take full responsibility. I don't blame anyone. And other circumstances that were going on could have been handled totally differently. I know that now. I didn't know that then.
I believe you just touched on it, but let me ask, do you blame JW for the loss of your license?
Absolutely not. Absolutely not. She had a right to do what she had to do. If I were her therapist, I would have pursued that with her too, to the degree that that was in her best interest, and she would let me know yes or no on that.
Has your wife expressed to you that the circumstances regarding your affair was painful for her?
Many, 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 many times. And I think the most painful, the day she found out was the day on her choice, she came with me in a supportive capacity in spite of that pain when I confessed and took full responsibility to every colleague at the Cerritos Psych Center. But yes, I'm sorry, I took long. Yes, she was. Many times.
Have those expression of pain played a role in your decision on who to tell about the circumstances?
Absolutely, 100%. I don't want to be responsible more than I already have for causing damage or hurt. I feel I owe her that, and whether that's a therapeutic issue or not, I still feel that way.
To your knowledge, has Cerritos ever initiated any disciplinary action against you?
0.
Thank you. No further questions, Your Honor.
Okay, I'm going to open it up to the board members in case they have any. I'm going to open it up to the board members in case they have any questions. Do we have any questions on this side? Go ahead, please.
My questions are about like the mentor-mentee relationships that you have with some of your students, and in particular the student number 1. Was that like a paid arrangement?
No, the idea of mentor-mentee relationship has kind of evolved over the last 30, 35 years. Some of that, most of that, is related to that semester grade issues, course issues, how to study, referring to the mental health clinic, that kind of thing. I had contact, I do network, last couple of years, network, bringing professionals, mental health professionals, and students from other colleges together that I have known. And my wife and I have this backyard party, not party wine, party networking, and where we exchange ideas and things like that. At those parties, I've been contacted 5, 6, 7 mentees that wanted my help at helping them understand the pros and cons of private versus public and getting into psychology graduate schools, because I had done a lot of studying on that and made a lot of contacts in that way. And that's where the mentee number 1 and mentee number 2 came from.
And were there, is that, so it's my understanding it's informal and it's not like...
No pay, totally informal. It's my maybe late in life giving back in lieu of the fact that I don't yet or may never get a license. It's one way I give back. And my wife is involved 100% with me, and in part it's her party too.
So those mentor-mentee like meetings, the weekly meetings, were they, so there's no contract, it's just like you meet at a certain location?
All informal. People
like,
can come and go as they please.
Is it at your house?
The networking party, there was only 4 in its total history, over 2 years. The mentee relationships, yeah, absolutely.
So it's in your house or?
Open door.
But like, where is it located? Like, do you meet?
Where do we meet?
Mm-hmm.
Sometimes Cerritos College, occasionally. Sometimes at a restaurant near the campus that they attend. That's probably the only places I can think of.
Okay.
Public places.
Okay, so I guess my second question, it has something to do with the fact that it seemed like JW misunderstood and saw herself as more of a patient, and that wasn't what you thought it was. So when you were meeting in those sessions, you thought that you were just having like an affair, but she somehow thought that it was that she was a patient of yours during that time?
I would say that even if I was blinded by my own feelings, I thought back then that maybe that first 9 months or so, we were a couple.
Mm-hmm.
and couples talk about things. She talks about things. She gives me feedback. I give her feedback. I still do it with my wife. That's how I conceived of it then. Yes, I could see that maybe she saw it differently, but never shared. Yes, there's a possibility that when I ended it, and the lawsuit and the board, that's how she's looking back on it now. That's possible too. I don't know. So I'm not 100% sure how to answer that. I do take responsibility for the possibility that I construed something that wasn't in fact there, maybe without checking it out. And I think that's true. I can tell you 100% there was some time that I knew, no doubt she knew, she was going into a therapy group with no pay, but still going in, and therapy was done. So I am guilty at that point, and looking back on it, it's kind of not so crucial what was thought then versus what was thought later. I'm still guilty.
So I have one more question, and it's with regards your rehabilitation. So, like,
My what? I'm sorry.
your rehabilitation.
Oh, rehabilitation.
Sorry,
Okay.
I have an accent, and sometimes I don't put the right, emphasis on the right syllable. So my, that you've taken the ethics courses, and the cornerstone of our field of psychology is, boundaries and informed consent. Those are all important in having an ethical, therapy practice. What is the biggest lesson about ethics and boundaries that you've learned from your experiences can make us more confident that you won't be repeating, that you're safe to practice?
I would say that it's not just an ethical rule put in a book for people to more or less follow. There's a reason behind it. People get in trouble. Patients get hurt. Or clients, I like to use the word client. Clients get hurt. Therapists get hurt. Families get hurt. I violated it. I feel that now. And certainly back then. So it has a feeling touch to me. Also, I myself was violated twice. Not on that level, no. There was no sexual abuse toward me. But when a therapist dismisses you and doesn't even bother to get back, that hurts. And that's not good therapy, period. When a therapist wants a dual relationship with you to be a spokesperson for distressed therapists everywhere, and this is an ethics committee psychologist who loses her own license, that hurts. And I have feelings about that. So it's not just knowing more about boundaries, conflict of interests, dual relationships, power relationships, never having sex with a client. It's feeling why those rules are there, experiencing it from my own life, both as a perpetrator and as a survivor.
Thank you.
Thank you. Dr. Gaffney, I just have about 3 questions myself. So why do you want your license back?
I love helping people in a way that I have a strong skill set to do. Of course, the last 26 years, it's been through teaching, which isn't therapy, and I don't do it for therapy, but I had it before. I've been preparing for 34 years to get it back, but I think my reasons are more positive now than just a do-over from the past. I want to give back.
Okay. So there are a couple things I don't understand. I just want to ask you from the materials that we have. First of all, JW was a former student. How long had it been since she was your student?
Not long enough not to feel the full force of the power relationship, the dual relationship, the violation of that relationship. And it's irrelevant whether back then it was more like a frontier on college campuses. I felt it. I knew it was wrong. I did it anyway. I learned from it. And so short period of time, but even if it were a longer period of time, I would still have some questions about it. Because you never know when she's going to come back and be a student again, and then you have a real problem on your hands.
Okay. Even though when you say, well, let me ask this other question. I'm still a little bit unclear the difference between, because you said several times she was a mentee, not a student. So I'm
JW? JDW was never a
mentee number 1 and mentee number 2. And you kept saying as you were talking, she was a mentee, not a student. These were mentees, not students. I'm still a little unclear about the
there was why they are even brought up, I have no idea. Certainly nothing formal or on record. I don't even know for sure there's an issue with them. And it is 100% separate from anything that went on with JW, and I don't even know anything. And the reason why the word mentees were used, they hadn't been students at Cerritos College for 2 years and older. And our contact wasn't through Cerritos College, but the network party or a referral from the network party to help them get into graduate school. And I volunteered that. There was no fee at all for that.
So how did that announcement or whatever it was get out to these people who were no longer students?
I have no idea because the college has not provided any input. I don't even know if it's a problem.
No. I'm talking about when you had mentees or met with mentees.
Yes.
How did they know that you would help in this way?
How did they know that?
Mm-hmm.
Well, partly because of word of mouth from working with mentees and also from the network party.
So when you had those network parties, how did
Yes.
that information get out to people who weren't students? How did that information
Oh,
get
I
out?
contacted former students that hadn't been on campus, and occasionally some students that were on campus.
Okay.
My wife made some contacts on her end and her own. So that's how the group got together. And I think the networking itself was positive enough that it wasn't unreasonable to ask if you know anything about how to work with the CV or personal self-statements and that kind of thing, and I did.
Mm-hmm.
And I learned more as I got going with it, too. And I was upfront about that I didn't know everything.
Okay. One more question, and I might have heard you wrong. When this first happened, did you say that you told your classes that this had happened?
Which is
that
this?
you had lost your license? You had been disciplined by the board? I thought I heard you say that.
No, I did not tell any class, nor would I. I think when you tell something like that, in my opinion, you need to have some reason and some selection, and you don't tell a group. You would tell an individual if there was a reasonable need to know, and I think my family would support that if there was a reasonable need to know, but not the class, no.
Okay.
Now, if it were a class and I was licensed and I was doing therapy demonstrations in the class, Yes, I think I would.
You
But
would-
not an education class, no. If I were
Okay.
doing therapy, licensed, then there might be a reason to know.
There might be a reason for your students to
Yes.
know in that instance.
Yeah, but that was never the issue and never the case.
Okay, thank you.
Questions?
Good afternoon, Dr. Gaffney.
Good afternoon.
Was JW your patient?
Yes, she was.
Did you have sexual relations?
Yes, I did.
Was it legal at the time of the accusation?
I don't think so, but I'm not 100% sure. I think it became illegal later, but I can't give you the year and date. But whether it was legal or illegal, I felt horrible about my judgment, and it wouldn't change even if it were illegal then.
Sure. If you could turn to page AGO 13, which
13?
13, correct. And this is I'm going to ask the attorneys here what exhibit that is because I don't know.
It is Exhibit 3.
3. All right. Thank you. Appreciate that.
I'm lost.
Um,
It'll take me a minute. I'm
No
not very
worries.
fast. Page 2? Okay.
AGO 13 is the accusation and outlines which portions of state law, in this case the Business and Professions Code, this was brought under. So starting with line 28 on page 13, which is paragraph N as in Nancy, it says, commission of any dishonest act or any act of sexual abuse, sexual relations with a patient, or sexual misconduct, which is substantially related to the qualifications, functions, or duties of a psychologist or psychological assistant. So this was the accusation in law at the time of the accusation. So was this against the law? Having sexual relations with your patient?
If this was back in 1985, then I would have to agree that it was.
In several times during your questioning by Ms. Johnson, you said, quote, this wasn't against the law then.
That's what I believed, but what you pointed out to me, I was in error.
Okay. And finally, based on what we just discussed with AGO 13, with the matter of law, how does that affect your perspective on rehabilitation in terms of admission of that?
Well, number one, this is the first time I came to terms with what happened then was also against the law. I don't think I feel any worse because I was about as deep guilt and shame and remorse as I could be. So I don't think it would be any, and I don't think my rehabilitation would have changed any. I would just be a lot more accurate about when it was illegal at the same time if I ever had a client that had an issue or problem like that. But it doesn't change my rehabilitation or my deep feelings of remorse and shame. No.
Understood. Thank you for your time, Doctor.
I have just a few questions for you, Doctor. I'm sure it's been a long afternoon for you. Have you told the Chicago School of Professional Psychology that you had your license revoked?
I haven't met with the director in person yet. It was done over the phone. That wasn't even the context of our phone conversations. I had invited her to my network party on October 20th. I'm doing a presentation on the Vietnam War.
Can we just hold right to the
okay.
subject? And have you told them?
I did not know.
Okay, thank you. You, at several points in your narrative statement, you used the word consensual, that it was a consensual relationship that you had with JW.
Yes.
Does that make any difference relative to your legal and ethical obligations?
To legal and ethical obligations, no. It makes a difference in terms of two people agreeing, but no.
Okay. One of the allegations you agreed to said you borrowed $250 from JW.
I had agreed to that. I have no memory of that at all. I have, if I did, I have no memory of whether it was paid back or not. In all honesty, she didn't have any money except what she borrowed from her husband. I just don't have any memory of that at all, in all honesty.
Okay. Is it fair to say that your memory was probably better at the time that you entered into the stipulation about specifics
Well, I would
than
say
it
it
is
was
now?
much worse because I was so distressed at the time.
So you agreed to an allegation not knowing whether it was true or not?
There were probably thousands of F's and G's and H and bits of information. And no, I don't remember my lawyer going through each and every single one in detail carefully. But what I was agreeing to in principle is violating her.
Okay. There were some allegations you intentionally disagreed with. Is that correct?
Yeah,
That you left
they
out of the
probably
stipulation.
yes.
Okay. Would you agree that beyond hurting families and JW and so on and so forth, you also hurt the patients you had in treatment with you?
Yes, I think I mentioned that by adding her to the group, there are a couple things that I did to them besides show distrust and carefree of boundaries. There's no way I could have devoted the same degree of caring if JW were a patient on similar terms to them. No.
What about other patients of yours, patients you had to terminate therapy with because you lost your license?
Patients I never had, you mean?
No. Patients you had to terminate therapy with because you lost your license.
Yes, there's all kinds of potential where they could be hurt too, yes. I don't know of a single case. That doesn't mean I didn't feel it and didn't worry about it, and you're right, in principle, that could be an issue too, and it's another area of violation.
Okay, thank you.
Any questions on this side?
Thank you for sharing with us this afternoon. I'm wondering if you could tell us what your understanding is of the relationship between the ethics code and law in California.
In 1985 or
No,
now?
today. That's this part of today. Moving forward.
Well, my understanding of it, as best I can, is that if it's a law, it's enforceable. If it's an ethics thing, it has the power of law, but is separate from law. And having the power of law, it can be enforceable too on a different level. The two often go together. And I just did not know. I don't have any idea what it would have mattered at the time, but I did not know in 1985 that sexual relations with the student and or a patient back then, client to me now, was against the law.
Well, you know,
It was still a violation, but
right. Do you have any sense of what the current ethics code might say about that?
about having a sex with the client?
Yeah.
Yes,
yeah.
I do.
And
I read the
particularly-
book.
Wait 1 second. Particularly between a teacher or someone operating in a professional capacity in psychology with another person who could be a student, or who could be what was it, an assistant in one of your courses, so you would be operating in your professional capacity. So are you familiar with what today's ethics code might say about that?
Yes, I am.
Can you tell us?
My understanding of present ethics code, probably going back not just in the last year, but many, many, many years, this would be considered a violation on several levels. Somewhat differently, but still violations in the student contract, because you don't have the presumption of psychological damage necessarily in the same way that you do in the patient context. As I tried to share with you, Dr. Bohutsis wanting me to be a poster child hurt. And if that hurt, what about taking advantage of a client and the potential psychological damage by having a sexual relationship independent of the ages matching and consensus being yes, but at some point, as I indicated, probably in 1986, I think the second year, it was very clear from the psychological sense that boundary was violated.
Yeah, I'm sort of trying to focus on moving forward and the rehabilitation, which includes, in my mind, your understanding of what are these guidelines that govern us as people who are working with the consumers of California providing service. But I just have one more question. And as I was reading in the interview you had with the investigator, and you talked about wanting to offer gifts to potential clients, were you to have your license reinstated?
Gifts?
Yes, the word gifts was used a number of times, meaning you had thought that you had various gifts to offer. You didn't say specifically that you were going to give them something tangible, but you talked about various gifts. And I just wondered if you could say a little bit about how you would define those gifts.
Okay, first of all, not gifts in any material sense at all,
No.
zero. If I used the word give, it would have been not charging the maximum fee that I could charge, because money is not the big issue, but there would be a fee if by giving, and
You were pretty clear that it wasn't anything tangible.
Okay.
It was something that, as a
the
psychologist,
gifts that I have, I don't think I would ever parade them in any way but a humble kind of way anyway. I have some strengths. Lots of people have strengths. I would like to share those strengths and some of my development, and one of them in particular, the ability, and sometimes I fail at this, self-care. And I think I have things to offer in that way, and I would love to be able to give it. And I think that's where I was hoping that I came across. And back to one of the questions, I personally don't think, even if there aren't legal stipulations to it, just a personal philosophy that people that work together shouldn't be having sex together. And I do not have a time restraint. There's no 2 years, 5 years. Why not choose someone that doesn't have a convoluted, complicated relationship like that? And if you can't do that, that's a red flag anyway.
Thank you.
Okay, any further questions? All right, with that, I know that it's getting very close to 5 o'clock. I don't want to hold our court any longer than that. So we get started with closing statements and we'll move on.
Thank you, Your Honor. 1993 is a long time, and petitioner's journey since losing his license in 1993 is certainly commendable. There are some significant concerns, however. The first concern is, does the petitioner have a full acceptance of his professional misconduct? It's unclear because he uses a lot of caveats. He consistently says that he never provided actual treatment to JW. He keeps saying that JW never paid him. He takes issue with several of his past admissions that he made in order to resolve his accusation. One of those admissions was that he entered into a therapy for services arrangement with JW, which he says now is not true. He says that it's her doing. It was her doing, not his. These caveats give us pause about whether or not he has full acceptance of his professional misconduct. But what also gives us pause is that he did not fully disclose his past misconduct to two key colleagues, including one of whom, Dr. Duff, who he considers to be his friend. He asked him to write letters that he knew he was going to submit as part of his petition for reinstatement to reinstate his revoked license. With respect to Dr. Ranquillo, he did not tell her the underlying circumstances for why he lost his license. With respect to Dr. Duff, he told her many years ago about part of that misconduct, but since then, he has not discussed it with her, including when he asked her for the letter, and when he took the letter and he submitted it as part of his petition. He hasn't withdrawn the letters. He knows they're being questioned, but he hasn't withdrawn them, and they remain a part of his petition. And so as a fundamental matter, the letters lack credibility. They should be disregarded. Moreover, they don't support his rehabilitation. To the contrary, his failure to disclose begs the question, does he have full candor? And does he fully own his past misconduct? And contrary to his statements today about the importance of self-care and communicating with others, does he really have the ability truly to do that? Again, these are longtime colleagues and a longtime friend. Second, and importantly, do we have the necessary assurances of personal and professional competency to demonstrate public safety so as to give a license to him back free and clear? He's not currently in therapy. In fact, we know that his last therapy was in 1995. He hasn't practiced in the clinical setting with patients since 1993. He's completed a handful of CE courses this year at the encouragement of the board. None earlier, at least none that he can corroborate with certifications. So his professional competency is also far from clear. Simply put, you have somebody who's not practiced for 26 years. That's a long time, and there's no concrete basis for giving him back his license free and clear. The totality of the evidence suggests that rehabilitation, clear and convincingly, is not supported here. So it would be my position, Your Honor, the board, that the petition be granted. However, if the board were, be denied. So just to be clear, it would be my position on behalf of the Attorney General's office that the petition be denied. However, if the board is inclined to grant the petition, we highly encourage probationary terms. We encourage the imposition of certain terms in particular. Condition number 4, practice monitor. Condition number 6, psychotherapy. Condition number 7, examinations, including the professional practice in psychology exam and the California Psychology Law and Ethics exam, both of those exams and the passage thereof being a condition precedent. And we would also encourage the adoption of condition 13, which is the educational review. Thank you.
Okay, before Ms. Johnson, before you go into closing, I know that I haven't admitted documents. Are there any objections to these documents that I'm assuming you'd like to admit all of the documents, 1 through 27? Parties have any objections to admission of the documents?
No objection, Your Honor.
The only objection we would have would be the statements made to the investigator in Exhibit 5. We'd ask they be taken as administrative hearsay.
Okay. Also, with regard to any of the letters of recommendation for folks who have not testified here today, those would be admitted as administrative hearsay as well. And with regard to the investigator's report, I can admit that under Lake versus Reed, which would say, obviously, any third-party statements would be admitted only as administrative hearsay. Any investigator's observations would be direct evidence. Any admissions of him would be direct evidence. So I'll admit the investigative report under Lake versus Reed. The letters of support would be administrative hearsay, and everything else is admitted.
Agreed. Thank you, Your Honor.
Okay. And I'll have to go through which ones those are. All right, so closing statement, Ms. Johnson.
Thank you, Your Honor. I also agree. It's been 26 years, and that is a very long time. 26 years ago, Dr. Gaffney surrendered his license. We good? 26 years ago, Dr. Gaffney surrendered his license. He surrendered it for misconduct that he fully admits today. We have certainly spent a couple hours now parsing out details in the accusation, asking him, back then, 32 years ago, did this happen or did that happen? But the overarching principle, what caused you to lose your license? He's been very clear over and over again. He violated his boundaries. He violated the profession's boundaries. He violated the ethics. He violated and abused a power of trust. He repeated that over and over again. And while we might look here and say, did you borrow this amount of money then? 32 years ago, he doesn't know. Or what happened on this specific date, 32 years ago, he can't necessarily tell you. But the overarching idea, the idea of ethics, the idea of what caused him to lose the license, Dr. Gaffney has been very clear of that. He violated the ethics, he violated the board standards, he surrendered his license because he did wrong. No one's disputing that, including him. And if this were 26 years ago and we were determining whether or not Dr. Gaffney should lose his license, then the answer, most likely, even as he admits, would have been yes. That's not why we're here today, though. The purpose of reinstatement hearings, the purpose of administrative hearings, are not to punish a licensee for past actions. They are to protect the consumers of California. They are to ensure that the licensee, or the person who holds the license, is moral, is ethical, understands their duties, is competent. And so we don't look at what happened 32 years ago in just isolation. Instead, we look at how has he spent the last 26 years. Who is the applicant or the petitioner that he presents to the board today? And we do that by looking at the petition and by looking at the last 3+ hours of testimony that he's openly given to the board. Starting with that of, and I'll actually just take it in the order it was raised by the state, the idea of candor and credibility. Certainly many amounts of focus have been looked at Dr. Ronquillo's letter. Dr. Ronquillo is not the only letter writer in this matter. The board has 14 letters from colleagues, from professionals, from family, from friends, who over and over again, including licensed psychologists, including other people who have worked with him in a professional capacity, who openly talk about how Dr. Gaffney openly told them about the situation. He's been open with the profession, and he's been open in the personal context. To say that he lacks candor, to say that he lacks truthfulness, to say that he's not sharing this, is contrary to the multiple letters we have. Instead, there's one letter writer who didn't know. But even if we look at that one letter writer, that one isolated, and we look back at what she told the investigator, certain key parts were pulled out of the interview. But there's another key part of the interview. Dr. Ronquillo, even after learning of the fact, even after stating that she felt this was a violation of her trust, she then goes on to tell the investigator, nevertheless, what she wrote in her letter reflects her knowledge of him mentoring students and how students respect him. Which means even looking back at the 10 years that she's known him, she has still found that students respect him, that he has a good relation with students, and that he serves the profession. And that's what these letters continue to have in common, that he serves the profession honorably, in a non-licensed capacity, and that he is safe with students, he's safe with boundaries, and he's safe to move forward. We then look at the idea of continuing education. Dr. Gaffney certainly did his 36 hours the board requests for a petition, and he submitted those documents. He also has testified that he has attended conferences for years, for decades, which in a licensed capacity would serve as continuing education. The state has raised a concern that these are uncorroborated, but if you look through the letters of support that were submitted by professionals, over and over again, they too reference that he was attending these conferences. There's even one student who mentions attending the conference as well. These are not just simply Dr. Gaffney's words to the board. This is a sustained period of him demonstrating that he has stayed engaged with the profession, he has stayed up to date with the profession, and that he has continued with the education as the profession has changed. He essentially has evolved with it through not only his work with the conferences, but teaching in the profession. Ultimately, this is not an easy task that we're asked of, or that you're asked of. I'm not. I obviously have a biased opinion on the answer. But fortunately, the board has given us guidance in terms of in determining a subjective feeling of whether or not someone is reinstated. How can we even tell that? And looking towards the board's criteria for rehabilitation, found at Title 16 of the CCR, we see the 5 characteristics or the 5 criteria that are laid out for what we should consider. Starting with number 1, the nature and severity of the acts. Nobody, including multiple times today Dr. Gaffney, denies that this was a serious violation that occurred from 85 to 87 that led to the surrender of his license in 93. And yet case law, facts, and common sense are very clear. There is nothing that one cannot rehabilitate from as long as they meet the other criteria. And so then we move on to criteria 2 through 5. Evidence of any acts committed subsequent to the acts or crimes under consideration or grounds of denial. No one has raised a subsequent act of concern. No one has raised any subsequent act that would cause the denial of the license. We went down slightly a rabbit hole of what led to Dr. Gaffney leaving Cerritos College. We discussed a lot of speculation, but ultimately what it comes down to is, even in the sparse interview that we have that even raised this question, Dr. Ronquillo, she's very clear that it was inconclusive and she has nothing to state on the matter. He's never had a disciplinary history raised by Cerritos. Cerritos has never initiated disciplinary actions. He was not fired for an inappropriate relationship with the students. And so therefore, we see that there's been no subsequent act or cause for denial. Subsection number 3, the time that's lapsed since the commission. It's been a long time, right? We are looking 26 years since surrender, but we're looking 33 years since the relationship ended. We're looking 35 years since the relationship began. We're looking for many people a whole lifetime, and how he's used that time has been wise. Moving on to subsection 4, the extent to which the applicant has complied with terms of parole, probation, restitution, or other sanctions. Dr. Gaffney was never charged criminally, and I'm certainly not going to impose any speculation in terms of answering illegal versus illegal, but this was never a crime that he was charged with. He never had any parole to comply with. He never had any probation to comply with. And there were never any restitutions or sanctions. As Dr. Gaffney testified, the civil suit raised by JW went nowhere. So then we turn to perhaps the most important criteria, evidence of rehabilitation. It's obviously a little vague, but we can take Dr. Gaffney's therapy, which was voluntary, his desire to not only start that therapy, but after the first therapist didn't work out, after the second therapist didn't work out, moving on to that third therapist, staying so engaged in the matter that he continued to seek out treatment, one after another, until he felt that he had fully addressed the issue. We can look at the continuing education. We can look at the way that he stayed up to date in the profession. He didn't leave the idea of psychology. He stayed engaged. He stayed connected. We can look at his community service and his volunteer work. He hosts these networking parties for no other reason except for he wants to bring people together to help students who enter into graduate school. We can look at the support of his family. We can look at the efforts he's made to tell his wife, to tell his children, and to respect their opinion and to respect their input, that he does not continue to share with others his affair unless he specifically gets their permission or seeks their guidance from them, instead of continuing to scrape at an old wound of his wife's. Case law has been very clear that there is absolutely no guarantee that anyone can ever offer that they are safe, and that's in the matter of In re Brown. In fact, they come out and they say, yet no absolute guarantee that petitioner will never re-engage in misconduct is possible, nor must petitioner show perfection. Reformation of a state is a state of mind which may be difficult to establish affirmatively and may not be disclosed by any certain or mistakable outward sign. However, the law still favors the regeneration of erring attorneys, in that case it's in a state bar case, and should not place unnecessary burdens upon them in proving rehabilitation. And so we look at, has Dr. Gaffney proven rehabilitation here? Are there concerns that he will reoffend moving forward, that he will violate those boundaries? As somebody who has articulated over and over and over again his understanding of where that boundary line is, of what the ethical duty is that's placed on him, as somebody who's able to articulate the difference between ethics and the law in a way that, as somebody who practices in administrative law, I'm not sure could be articulated off the top of the head, then we can see that here is somebody who has full acceptance of his responsibility, who has never swayed from that in the 3 hours that we've questioned him on it, who has continued to who has continued to hold his truth in this matter, as somebody who has stayed up to date in the profession, as somebody who has returned to the profession with the goal and the idea of giving back. That's the type of licensee we should be looking for, and also that's the type of rehabilitation when looking at the criteria that the criteria supports in terms of granting the petition. And so because he meets these qualifications, because there are guidelines in place by the board that allows them to continue to watch him as he shows and demonstrates to the board that he meets these qualifications, we respectfully ask that his petition be granted. Thank you.
Thank you. All right. With that, the matter is submitted and the record is closed. And if you'll wait for a moment, I'll get a copy of the board.
So, this won't come any further.
What do we do?
Let's move to it.
I'm sorry.
We're now going to go into closed session of indeterminate length. We will be convening again tomorrow at 9:30 a.m. At that point, we will still be in closed session. We'll be resuming closed session for purposes. And as a result, at the very earliest, for those of you that want to attend the meeting tomorrow, I would say the earliest 10 o'clock, and that may be wishful thinking. I would say 10:30 more likely. So all that being said, we will now go into closed session. Thank you very much.